there?
So we have been talking for a couple of weeks now about the prohibition against giving false witness. And we looked last week at some of the issues relating to witnessing and testimony and evidence and that kind of stuff. And we finished with looking at Numbers chapter 35, verse 30, where the Lord says, if anyone kills a person, the murderer shall be put to death at the evidence of witnesses, but no person shall be put to death on the testimony of one witness. Now there are other kinds of situations, non-death penalty situations, where one witness is sufficient. It's only in this particular situation that someone is going to be put to death that more than one witness is required. So God is putting an extra standard in place to prevent people from being executed on what might be less than substantial evidence, less than accurate. You know, somebody one person sees something, maybe they misunderstood what they saw, maybe they didn't see what they think they saw. Two people see the same thing, hopefully at least you've got two perspectives, and as a result you would have two, you'd be able to corroborate and make sure that there was consistency between the testimony.
And since God knows human nature, it's also a boundary against, oh, I don't like that guy, I'm going to get in trouble.
Right, exactly. Yeah, so it is also a way to prevent false statements from being as likely to be admitted. Now, as we saw in the case of Jesus, obviously when the system is corrupt, it becomes much, much easier to get false evidence. In fact, you can have judges who go looking for false evidence, as they did in Jesus' situation. So certainly, just because you have prohibitions, just because you have rules, doesn't mean that people can't find ways around those rules, that the rules are never going to get broken. And that is a reality in our justice system as well. The simple truth is that innocent people do get convicted in our justice system. The work of the Innocence Project, which has gone back in a number of cases that were pre-DNA cases and used DNA evidence to actually take a look at the, for example, blood and things like that on some of the clothing and different things like that, has at a fairly high rate, because they cherry pick their cases. They don't just take anybody. There needs to be significant reasons for them to think that it was a bad conviction. So they're already kind of aiming for the ones who are most likely to have problems. But they have a significantly high rate of finding out that in fact the person was convicted wrongly. And it can happen because of eyewitness testimony. It can happen because of circumstantial evidence being misinterpreted, or a situation where everything looks like the person did it. There's lots of evidence to suggest that there's motive, there's opportunity, but it just turns out that wasn't the person who did it. That happens. That's the reality. And that's just in the cases of murder. When you take it out of the range of murder and the death penalty, where there's a lot of additional prohibitions and safeguards, there's a not insignificant number of people who are in prison who are not guilty of what they've been accused of. And I don't want to say it's like 10% of the population, the prison population or something like that, but it is a significant number. And unfortunately, there's very little that you can do to completely eradicate false convictions or wrongful convictions. Even if you got rid of all the people who were testifying falsely, you still have a lot of other ways that mistake can be made. But our system is designed to try to minimize those through the rules of evidence, through the use of juries, through the requirement that defendants be represented by counsel in cases where imprisonment is a possibility. There's a variety of different procedural safeguards that we set up to do this. In the case of the Israelites, adding an additional witness requirement was the main prohibition or safeguard. But remember that all of these kinds of trials took place in the presence of the clergy, as it were, the priests, the Levites, and so in theory at least, these sorts of things should have had the additional safeguard of people of good character, and perhaps even people with a connection to God, being able to sit in judgment on them, which in theory, again, would tend to increase the probability that the right thing would be done. Again, Jesus' situation shows us that those assumptions don't necessarily work when human nature gets interposed over the plan that God has for how the system is supposed to work. So the idea, though, is that there needs to be at least two witnesses, and we'll see later on in the New Testament with elders, bringing a charge against an elder requires witnesses or evidence from at least two witnesses. that there was something done wrong. When Paul quotes the Old Testament, he doesn't specifically refer to the fact that it was about murder. He just refers to the notion of two witnesses as being something that's necessary for an accusation against an elder to be entertained as well. Okay, so we have this idea that we want to make sure that testimony is not only true, or in the sense that the person isn't lying, but also that it's accurate, which is why ideally you want to have more than one witness, because one witness can be inaccurate even if they're trying to be truthful. Okay, so let's expand this a little bit more. In Deuteronomy chapter 19, it says, "A single witness shall not rise up against a man on account of any iniquity or any sin which he has committed. On the evidence of 2 or 3 witnesses, a matter shall be confirmed." So, we're talking about sin, we're talking about iniquity. This is broad enough that this could actually refer to any kind of sin. In practice, this most often was referring to the kinds of sin for which you could be executed, because in the Jewish law, not only could you be executed for killing someone, but there were a number of other sins that you could be killed for. We've looked at some of them, adultery and different things like that, where you could be taking God's name in vain. Yeah. So in practice, this was most often applied there. But strictly speaking, if you read it in the most liberal way possible, it would basically say any sin, any iniquity. But this is where things get interesting, because there's a penalty for what we would call perjury. Because he says, if a malicious witness rises up against a man to accuse him of wrongdoing, then both the men who have the dispute shall stand before the Lord, before the priests and the judges who will be in office in those days. The judges shall investigate thoroughly, and if the witness is a false witness and he has accused his brother falsely, then you shall do to him just as he had intended to do to his brother. Thus you shall purge the evil from among you. The rest will hear and be afraid, and will never again do such an evil thing among you. Thus you shall not show pity, life for life, eye for eye, tooth for tooth, hand for hand, foot for foot. Okay, so this is interesting because this is a specific prohibition against perjury and a method for dealing with it. Can you imagine if this version of perjury was used in our modern society? I think fewer people would lie on behalf of somebody else if the result was that you had to suffer whatever penalty the person who was charged with the crime was under if you lied about it. But you notice here this notion of deterrence as well. What does deterrence mean? We talked about this a little bit before.
You're making the punishment harsh enough to where others around aren't going to want to do.
Okay, so the key to deterrence, or the goal of deterrence, is so that other people will not want to do whatever it was that you punish someone for doing. And so in this case, he says, you want the rest of the Israelites to hear and be afraid of what happened to this person who lied about their brother and tried to get them convicted for something they didn't really do, and then they won't do it again. But you notice also this kind of an interesting thing. It says, if there's a malicious witness that rises up, now obviously you wouldn't know that for sure, but the idea is that if the witness rises up and the other guy says that's not true, then you go before the priests and the judges who were in office in those days, and it's not talking about judges in the sense of the book of Judges here, it's talking about the judges who are deciding the cases, and before the Lord, and the judges shall investigate thoroughly. The job of the court in this context, in part, was to investigate. How would a court in those days go about investigating what these two people are saying? What do you think?
Personal interviews with others that might be familiar with the entire situation.
Okay, so you're going to look for witnesses either to the specific situation or about the character of the men involved. What else? Anything else?
Maybe if the false witness got, like today, got paid off of something, he can afford things.
Okay. So you might, as I'm trying to remember who the attorney is who said this, you might want to follow the money, see, where that might have gone. If this guy suddenly had 30 pieces of silver he didn't have before, that sort of thing. Okay. What else? Anything else?
Why not just call CSI and go look at
yes, we'll do some forensics investigations. Yeah, probably not.
Okay.
Good try, though. Anybody else? Any other thoughts? I'm not looking for anything in particular. I'm just kind of wanting you guys to sort of think it through.
Probably the same circumstantial evidence that might be available on any crime, that they would investigate, you know, did he have the bloody knife in his hand?
Okay,
I'm sure was part of
Okay.
the investigation.
so you'd be looking for evidence that the sin had been committed in the sense of, you know, whatever would prove that that might be the case. Steve?
I would say I would investigate why they're giving false witness. What's the
Okay.
reason?
So normally, what's interesting is that this suggests, the way that this is written suggests that normally when somebody would come and say so-and-so did this, that so-and-so wasn't necessarily going to say, no, I didn't, but rather they were going to acknowledge it. I mean, that was the theory anyway, that they would acknowledge it and then things would be made right. But when somebody says, no, they didn't, then one of the questions you have is, well, why would the other guy lie about it? And so one of the things you would go looking for are reasons why they might lie about it. You know, money, as somebody said, would be one, but personal animosity, some kind of a history, whatever it might be, you know, some kind of family rivalry. There's a lot of different things that you could look for. So that's probably going to be a matter of investigation, maybe even listening to rumors a little bit, trying to sort of figure things out. So this is not a super simple process any more than investigating a crime is today. But in this case, it's the judges themselves who have this job. Now this is very different from our system, because in our system, the judges, whether you're talking about the judge who sits in charge of a trial or what we call the triers of fact, who might be the judge or might be the jury, do not have an investigative role when it comes to trying a case or to developing a case. Whose job is it to investigate cases?
Law enforcement.
Law enforcement in general, and to a lesser extent, the prosecuting agencies may also have a role in doing that as well. So ultimately, in our system, we've split it out so that you have what is in theory a neutral trier of fact with a neutral jury or judge along with that, and then you have the side, the investigative side, the prosecution and law enforcement, and the defendant's side, who may also choose to bring in and do investigations as well to try to demonstrate innocence. Okay?
When you worked in the county prosecutor's office, did you have your own investigative individuals, or did you depend entirely on the law?
We did actually have a small team of investigators. They were almost uniformly ex-law enforcement. Either they retired or in a couple of cases they...
Skill set.
Yeah, well, exactly. Or in a couple of cases they'd come to work for us because they were tired of having to wear black and white uniforms and run around the streets. But we had, I forget, in our office, which had about 60 or so criminal attorneys, I think we had fewer than a dozen investigators, maybe as few as 6 or 7. And then we didn't routinely use them to investigate crimes, but they served several important purposes. One was that they served subpoenas for us. So if we needed somebody in court, our investigators were the ones that went out and served those subpoenas because we could rely on them to do it correctly and accurately and that sort of thing. They also would do investigations, like if we needed a witness re-interviewed quickly, or if we had some concern about some of what we were seeing in a police report, we might send an investigator to go talk to somebody. And they could be called as witnesses. In fact, they routinely were called as witnesses. And they brought a different perspective usually than a pure law enforcement officer would. So they had a variety of different roles in the office. But they were, in a few occasions, they also actually served as sort of a protective detail for the county attorney if she was going into a particularly problematic situation or something like that. That one was very rare. But that was part of our office. And most of the larger county attorney's offices and prosecuting offices do have some investigators that work for them where they can use them exclusively without having to kind of work through law enforcement that may have different priorities. So in this case, though, the judges are not intended to be impartial. They're impartial in the sense that they're not supposed to have a side, they're not supposed to favor one side over another, but their job is to go out and learn for themselves what actually happened and then use that to inform a proper judgment. Whereas the job in our system of the judge or the trier of fact is to listen to the presentations of evidence by other people and to then make a decision based on that evidence. And we prohibit our judges and juries from, well, the judges maybe not so much, But whoever's actually doing the trial, whether it's the jury or if the judge is sitting on the trial, they're not supposed to go and investigate for themselves. They're not supposed to go check and see if a defendant's statement could actually be true, or if the timeline matches up in somebody's version of events. That's the job of the two parties to do that. And so we have chosen an approach that theoretically is designed to create more neutrality in the situation. But I'm not necessarily sure that that's better than, or so much as just different than, the idea of having the judges go and try to learn it for themselves. Because ultimately, by going and learning it for yourself, you take away that layer of, what's going to actually get to me versus what's actually out there. And you provide the judge with more direct information and understanding. But in any event, the judge's job is not simply to verify that the person committed the crime. The judge's job to figure out what really did happen, if the person was a false witness, and if so, perhaps why, but then ultimately to do to them whatever the consequence would have been to the person that was accused. So this is an interesting system. Now in our system we do have perjury. Perjury is very difficult to prove as a practical matter, because perjury, what is perjury? What do you think perjury is? What do you mean when we say perjury?
Lying under oath.
Lying under oath, okay. And most people would say that that's true, and that is true, but there's one element to it beyond that, and it's that extra element that makes it really hard to prove. Because the other element is you have to lie under oath for the purpose of influencing the outcome of the proceeding. So, if I put you on the stand and I ask you what your name is, and you say my name is Ron Jackson, more often than not, that's not going to be considered perjury, because what your name is has very little to do with the case, unless for some reason your name was significant, like you were related to the person and your last name would have made that obvious or something like that, then maybe it's relevant. But for the most part, a lot of the things that people say on the stand are whether they are going to affect the outcome of the trial is you don't know for sure. And the person can argue, I didn't intend to influence the outcome of the trial. And because intentionality is an element of this particular kind of crime, it becomes very difficult to prove perjury. Now there is a lesser offense that is basically, depending on the jurisdiction, is basically called lying under oath, but the penalties associated with that offense are very, very low. And that would be the kind of situation where you provide something like you give the wrong date of birth because you don't want to admit how old you really are, or you tell a lie, but we can't really prove that you intended to influence the proceeding, you just lied. In both cases, though, very few prosecutions are begun for either of those two cases. For perjury, because it's so hard to prove. For lying under oath, because it's so pointless to prove, because the consequences are so minor, it's usually not worth doing it. And the problem with either of them, particularly with the one about lying under oath, is you can kind of start to scare witnesses if they start thinking, well, what if I make a mistake up there? Am I going to be prosecuted for lying under oath? And so we don't want to necessarily do that unless there's a really compelling reason to do it. So unfortunately, perjury is very rarely prosecuted. Now, and there again, the penalties for it are, I forget what perjury is in our cases. It's either class 4 or 5 felony, which is a relatively middle to low level felony, and there's a good chance you wouldn't even serve prison time for it. It would depend on maybe on how severe the outcome was. But the reality is that it's way different than what is proposed here, which is that whatever you lie about is what you receive the consequence of having lied about it. Now this particular one is talking only about someone who accuses someone falsely. Perjury, as often as not, comes up by somebody lying on behalf of a defendant to try to get them out of trouble. In our modern system, it's much less common that we encounter perjury by a prosecution witness than by a defense witness, although it's not it does happen. But and there's nothing in the law of Moses to really address that issue other than just the idea that you're supposed to speak truthfully to one another.
I was going to say, too, even that reading right there, first of all, you're being tried by the Lord. That's
right.
God. And we tried that. And I don't even know if it's changed. I haven't been in court in such a long time. We used to swear to God that
right.
You're telling the truth. To me, that's everything.
Right.
To us as Christians, that's everything. We're going to try to tell the truth, so help me God. But to this world now, they don't fear God. They don't fear God like we do.
Yeah,
So they can say whatever they want, and there is no consequences to that. And we can see even in our own justice system, there is no consequences for lying,
Yeah.
period. So, you know, and to change that, it's almost impossible now, because the world has went the other way.
right.
But to us as Christians and to people who believe in God, when you say that, that means something. But to other people, the worldly people, that means nothing. So
Yeah.
have they changed that now?
Oh, yeah, so the standard oath when you want to testify is, I swear or affirm that I will tell
That's
the
it.
truth. And so now you can, if you want to, say, I swear to God, or however, whatever phrasing you want to use, as long as it encompasses either the word swear or affirm. You could do it however you want to, but you have to give one of those two things. And that began actually, ironically, with a religious group, because the Jehovah's Witnesses in particular were unwilling to swear to God or by God, and there were several other Christian groups that wouldn't do that. And it expanded to atheists and agnostics and all sorts of different groups. And so at this point, it was easier for the justices to just say, okay, we're not going to make it that. We're just going to do whatever. And the problem, of course, as you identify, is that even if you still had it as I swear to God, if you don't believe in God, who cares, The reality actually is, what's interesting is, perjury is not as rampant a problem as we tend to think it is, at least not in terms of people actively lying to cause a case to go wrong. It doesn't have as much as you think. And for evidence of that, consider, for example, that most defendants don't take the stand in their own defense, because they don't want to get up and be put in a position where if they might be trapped in their own words, they might have to lie, and then they would face perjury. Because the one time we will go after people for perjury is if it's a defendant who testifies on their own behalf. Because then it's really pretty easy to argue they did it to influence the trial. Because why else were they on the stand testifying in the first place? So that is the one place where you could actually win a perjury case with a decent chance. But you think about the other aspect of it when it comes to the court hearings today is, for people who are in certain kinds of jobs, being honest in court is a necessity as a practical matter, or failing to be honest in court has consequences that exist independent of being caught and being prosecuted for it. So, if you are a police officer, if you're law enforcement, if you are an attorney, if you are someone who is involved with financial transactions, those kinds of things, and you are found to have lied in court, even if you're never prosecuted for it, there's a really good chance you're going to lose your job, and you're never going to be able to work in that field again because of the need for trust in that field. So police officers who lie under oath, prosecutors are required to keep a file on police officers who've lied under oath, to provide that list or the name of that person to any defense attorney in a case where that officer is part of the case. And that almost immediately undermines the values from a testimonial standpoint, which very often leads the law enforcement agency to fire them. Because a police officer who can't testify in court is not a very helpful police officer in a lot of areas. Because basically what it means is that they're only able to do about 2/3 of their job. And that last third, which is to get people convicted, is gone. Prosecutors, in general, attorneys who lie in court can be disbarred, suspended, and the state bar is pretty enthusiastic about pursuing those kinds of things, because we don't like attorneys who lie in court. Lying to your clients even can get you in trouble, but especially lying in court. Like I said, people who are involved in financial kinds of things can lose their licensure, can end up getting fired because they're, again, the fiduciary duties of trust and things like that. So there is actually, in some ways, a higher level of consequence for lying in court through society's methodologies than there is through the legal system itself. And one of the interesting things you see is you will hear attorneys who will get up in public and they will tell you, how they're going to do this and they're going to win that and they're going to show this. And then if you want to know what's true, don't listen to what they tell you in their news conferences, listen to what they tell you or what they file with the court. Because what they file with the court is required to follow a standard that basically says there has to be at least some evidence that I believe is credible that would lead to, that would support the position I'm taking. So I can't get up and say, I think so-and-so did it, not my client, unless I've got some evidence to back that up, I can't just get up and say that. To do that would be possibly get myself suspended or disbarred. So attorneys will say whatever they want to in front of people, but when they go into court, it's a different game, and that's when you get to find out what's really true, or at least what they really think is true, because that's when they will say they'll argue only what they think the facts actually support. And the same thing is generally true with a lot of people. A lot of people realize that if you are caught lying in court, there's a good chance you're going to end up losing your job and losing trust and becoming publicly poorly known. And so it is interesting how many people who have said one thing when they get put on the stand say something different that isn't as advantageous to themselves or to their friends as it was when they first talked to police, or who get up and they just can't remember anything. The one thing you can do if you never want to get charged with perjury is to get up and say, I don't remember. Because nobody can prove that you don't, whether you remember or not. So all you have to say is I don't remember it, and then you're pretty much done at that point. And so you will see that happen quite a lot. But in essence, though, even though the criminal penalties aren't there, it's a relatively rare occasion where I encountered where I knew somebody or felt very strongly that somebody was lying in court. There are times where I thought somebody was maybe either mistaken or shading the truth. There are times when I felt like somebody was saying some stuff, and the way they were saying it made me really worried that they weren't telling the truth. There's only been a few times in all the cases that I tried where I really said, this person is almost certainly lying. So it doesn't happen as often as you think, because people do, or historically still have put a certain amount of value in the system. And I think we're moving further and further away from that. I've been out of prosecuting for more than a decade now, and I'm pretty confident if I were going to watch some cases, I would realize that there's a lot more people that are willing to lie now than there used to be. But that's the reality of most societies. They degrade over time.
I do understand how God knows us so well. He knows that He says, I'm going to put consequences on you if you lie about your brother.
Right.
It's not just, hey, I can lie and so what?
Right.
He says, look, if you lie about it and you want to kill this person, literally have the judges do it, then guess what? It's going to happen to you if we find out that you've lied. So it's just the same way.
Right.
And I like the part that he says, in that way, we'll purge the evil out of you.
Right.
And I think that's the most important thing here. God doesn't want evil in His people.
And that's the thing, because of evil within the system, evil within the people is what leads to that degenerating system. And so when you allow that to stay and you allow that to percolate, it just gets worse and worse. Myself, I sat down, this is many, many years ago, more than 20 years ago plus now. I was not working as a prosecutor at the time, this was before I was hired for that. But myself and another attorney who were working as contracts managers on a slow day started talking about, I forget which case there was. This was after the O.J. Simpson case, so it wasn't that. We were talking about a particular case involving a guy who committed quite a lot of crimes. And I kind of think it might have been the Bernie Madoff case, but that may have been a little too recent. For those who don't remember, Bernie Madoff was a guy who created a Ponzi scheme that defrauded people out of something like $3 billion. The biggest Ponzi scheme in all of history. So anyway, other than Social Security, but that's so whoever we're talking about, all we're talking about is the calculus of crime. And basically the way you calculate whether a crime makes sense is by multiplying what you're going to get from it by what the likelihood is that you're going to get caught by what the penalty for getting caught is. So, if you rob a Circle K, you are a mathematical idiot, because the maximum amount of money that you're going to get is about 50 bucks.
Yes.
Now, even if your chance of getting caught is low, say 10%, if you are caught and you rob using a gun, you are looking at a guaranteed 10 years in prison because you used a gun in the commission of an armed robbery. So 10% chance of being convicted times 10 years is 1 year. How many of you think that you could make more than $50 in 1 year of doing an honest job? Right? So the math says that most crime is stupid. Now, I'm not talking about like crimes of addiction. Those are a different animal altogether. I'm not even necessarily talking about crimes like your average murder of passion or things like that. Talking about crimes that have a financial element too. But, and that's because we're talking about, like I said, whoever we were talking about, he had stolen a bunch of money. So when you look at those calculuses, one of the problems that we have as a society is that those two factors that tend to cost you something as a criminal, how long you're going to spend in prison and how likely you are to be caught and convicted, typically are not enough to discourage the more serious kinds of crimes in a lot of cases. And on top of that, we haven't done a very good job of educating our public about the consequences of some of the stupider crimes, like robbing a Circle K or whatever it is. And so here we see God setting up a system that's designed to do the opposite. Number one, it's designed to punish at a very high level for what you're doing, and it's also designed to maximize the likelihood that you're going to get caught if you do it. And on top of that, it's designed to make sure that everybody knows what's happened so that you publicize the consequences. So I find it fascinating because the concepts of deterrence and modern day deterrence theory, and in general, the modern day theory of deterrence is it doesn't really work very well because of all the problems that our system has in doing the things that it needs to do. So deterrence is a theory that's been around for quite a while, but deterrence is actually thousands of years old. God came up with deterrence long before, a bunch of criminologists and politicians did, and God understands how deterrence works. And a lot of the ancient societies did as well. If you steal something, get your hand cut off, that's a pretty good deterrent, So stuff like that, that awareness of the need for high level of penalties. Now, our system is trying to balance the need for penalties with the possibility that we might convict wrongly and that you can't undo things like cutting somebody's hand off or something like that. But nevertheless, there's a pendulum, and that pendulum has swung very far in the direction of minimal consequences for most actions today. And that unfortunately has resulted in a lot more crime. And I'm not just talking about violent crime, I'm talking about like property crime in particular. Property crime is so rampant in our society. A lot of communities just basically stopped accounting for property crime. Especially some of the ones in California, Portland doesn't keep track anymore, there's no point. So that's kind of where you get to when you don't have a connection between consequence and decision making. So, okay.
Or the consequences take 15 years to accomplish.
Yeah. So time is can be another factor, and that is we weren't even calculating that in the calculus we were using. But yeah, when you have even a relatively minor trial takes 2 or 3 years. And a death penalty type of case can take 15 to 30 years before all of the appeals are adjudicated and everything else. It starts to get to the point where it's hard to really see where the consequences are clearly done in. That's one of the arguments that I think is probably the strongest argument against the death penalty is that we've created so many safeguards around the death penalty that we've actually rendered it less effective than simply sentencing people to life in prison, because you get so many different appeals, so many different opportunities that it just tortures the victims' families, it just draws out the cost and the time that's involved, and spending your life in prison is no picnic for anybody. So you kind of wonder about that. What's interesting is that as more and more communities and states have taken that position, that it's just not worth doing it anymore, now there's a new movement that's coming up. Oh, okay, we're not doing the death penalty anymore. Well, now we need to apply all those provisions that we had about the death penalty and appeals to sentences of life in prison or over more than 25 years. So it's always a moving target with the people who are opposed to strictly punishing people for crimes. They always want to find a way to reduce, they want to find a way to minimize, they want to find a way to give more appeals, and it's never enough, basically.
I was going to say, is that why, at the end there, he says life for eye, tooth for tooth, and all that, because the consequences stay at a certain level. And it's now, we've made it to where they did it because it's not their fault.
Right, well, yeah.
And so there's never no consequences for somebody who's continually being a victim, even if they make a bunch of other victims themselves.
Right.
So
Yeah,
with God, it's like, okay, look, life for a life, or so on, and we're going to purge this from you. If you don't, then that's what happens.
And what we have now are what are called pre-sentence reports. So basically, if you're convicted of a crime, your sentencing is set anywhere from 30 to 90 days out from when the conviction took place. And between that time, if you're the person who's convicted, you meet with a probation officer who asks you questions, tries to determine whether you're remorseful, tries to determine what sorts of things might have made you do the things you did. They may interview family members. They interview one group that they almost never interview is the victims, which I think is interesting. The victims are allowed in our system, at least in Arizona, to make to provide statements to the judge, but the probation office doesn't interview the victims because they don't really care what the victims have to say. Their job is to try to build a profile of the offender, not of the offender's crimes necessarily. So ultimately, those reports read a lot like justifications. You know, here's all the reasons why they did this and why they really couldn't help it and why, you know. Now, at the same time, they do end up, in many cases, advising some fairly harsh punishments. So they're not, it's not like these aren't written by a bunch of, you know, people who are pro-crime or pro-criminal. It's just that they spend a lot of their time talking about all the things that went wrong in this person's life to minimize why they're responsible for what they did. And what's interesting here with the passage that we're looking at is when God says life for life, eye for eye, tooth for tooth, hand for hand, foot for foot, who is he talking about? Who's that going to be done to?
The victim, I mean,
A false witness. So it's interesting, now other places, and Jesus quotes this in the context of the Sermon on the Mount, but other places this is used in the context of what you did to somebody else is what will happen back to you. But what's being done here, what God is actually specifically saying here is, whatever the consequence would have been for the person who was accused falsely, that is what you need to do. Even if, and this is where it's a little tricky, because normally you say, well, they didn't actually, the person who lied didn't actually do that. All they did was tell a lie, you know. And lying isn't nearly as bad as murdering somebody or committing adultery or whatever. But because they set the other person up for that consequence, the result is that you have to do to them what they would have had done to the other person. And so that can be a life for life, or an eye for an eye, tooth for tooth, whatever it is. So in this case, it's not talking about what you actually did to someone else. It's talking about when you lied about somebody else and tried to have something happen to them, what should be done to you. So the principle exists in both contexts, in both the context of what is the consequence for what you did, and in the context of what is the consequence for what you've said and tried to have done as well. So, okay. Okay, let's actually wait on this. We're already at 10:15.